On all my videos I will be commenting as a private citizen and with my own opinions. If you are looking for a lawyer reacts style channel, email me and I can recommend several very good ones. That being said, I am a retired lawyer with over a decade of experience as a prosecutor and over 15 years as a criminal defense attorney. I taught other prosecutors, as well as at the police academy. Additionally, I taught pre-law at the undergraduate level. Given that I have that level of experience, I can't help but approach every video I comment on with my particular set of skills. What I will not do is offer any legal advice, so please don't ask. Absolutely nothing in this video constitutes legal advice. If you are in need of legal advice, please retain competent legal counsel in the relevant jurisdiction. Take everything you hear from a YouTube video with a grain of salt. There are a lot of people on here offering legal advice that are not competent to do so. Please always consult a competent lawyer for yourself.
Thank you, Your Honor.
Conditions. Thank you, ma'am. Court calls the cases of the people versus Shakaya Alton Ryder L.
Caitlin Kirby on behalf of the people.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Adam Ryder L. And sir, can you unmute and state your name for the record, please? We did just speak with him this morning. If we could pass briefly, I can see what's going on. I don't know why he's not here.
In my day, we would ask that the matter be dropped down the docket. At which point the defense attorney would run out into the hall and call for his or her client. They'd purposely not check the restroom so that they could say that perhaps their client stepped out to use the facilities. Anything to buy a couple extra minutes so that a capias wasn't issued.
Where is he?
I don't see him logged on.
Is he intending upon being here?
My understanding was yes. Upon the conversation I had with him, we were going to be asking for an adjournment. I did go over the discovery with him, but he says that he has some discovery of his own that he would like me to see before we make any decisions.
Well, he needs to be here.
If I could call him, I will try to get him on.
Or pass those matters.
This attorney has done a good job for her client. By saying that there might be some additional discovery to review, and so long as she has made a good faith representation that additional discovery exists, she has laid the proper groundwork for a continuance.
Court calls the case of the people versus James Johnson.
People.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Johnson. And so can you unmute and state your name for the record, please?
Yeah, James Johnson.
And Mr. Johnson does want to set this for jury trial. I did explain to him there's typically a final settlement conference before that. He is objecting to any date before the jury selection date. I'll just leave that. He's objecting to there being any date.
I don't care.
Okay, I just wanted it on the record. Fair enough.
I set the date. I don't know how he can even have an objection.
Understood. Okay.
Here is a great example of an attorney knowing that her client wants something said in court that is not legally justifiable, but her client is insistent that it be said. Rather than fight with her client, she makes the statement, already knowing what the judge is going to say. The judge shuts it down. Hard. This judge has a great sense for things, and this attorney did a great job of telegraphing to the judge why she said what she said. This judge has been around the block long enough that he understands what is happening all too well.
Well, it doesn't matter.
May 4th, 2022, 1 p.m.
What's this for?
That will be your final
jury selection. May 6th, 2022, 8:30. On continued with its conditions.
I just still want to set it out. Like, man, this shit is crazy. Come on, let's play.
Okay. He's going to be found in contempt.
Certified.
This is a great example of a client doing exactly the wrong thing. Once a judge has made a decision, it is never good to get mouthy with him. Judges have a lot of authority. At the point prior to mouthing off to the judge, the judge had continued the defendant's bond. After the defendant mouthed off, he cancelled the bond and found him in contempt. The lesson here? Keep your mouth shut and let your lawyer do the talking.
I want a camera on him right now. If he doesn't have a camera.
Sir, can you turn your camera on, please, Mr. Johnson?
Hi. You got something to say, Mr. Johnson?
What you want me to say? I mean, you're already talking about the contempt of me. So I ain't gonna say nothing for you to issue out no warrant, none of that. I'm smarter than that. So what you want me to say?
Okay. Does he really want to play this game with me, Miss Kleeman?
I don't think he does. Sir, I would advise you to remain silent. Our next court date is May 4th.
Thank you. Food a minute.
It is unclear from the audio, but I think the attorney saved her client's butt and the judge changed his mind on issuing the capias for contempt. Again, we see an example of a bad defendant but a good lawyer.
Court calls the case. People versus Kyle Zelkowski.
Caitlin Kirby on behalf of the people.
I messed it up again.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Zelkowski, I believe is how it's pronounced. Sir, unmute and state your name for us, please.
Yeah, good afternoon. Kyle Zelkowski.
Hey, I did it. I was okay. I was in the ballpark. All right.
All right. And he would like to set this for final settlement conference, please.
Final settlement conference, May 4th, 2022. 1:30, jury selection. May 6th, 2022 at 8:30. Bond will continue with its conditions. Thank you, sir.
Thank you. Oh, and I'm sorry, Judge. I believe the complaining witness is here. I don't know if Ms. Kirby has had a chance to speak with her. She may want to address the court.
That is correct, Your Honor. Sorry. The victim made our victim advocate aware that she would like the no contact changed to no non-consensual contact and would like the no go to removed. I do believe that she is on the Zoom call.
Hold on to your seats, boys and girls. Things are about to get interesting.
She's listed as Miss Parnell.
Miss Parnell?
Yes, I'm here.
Okay. What do you want to tell me, ma'am?
I was really hoping to have the no contact dropped, if at all possible.
Okay. Is there a particular reason?
We do have 2 kids under 2 years old. He is technically head of household financially. It was just a very bad fight.
Okay.
And I do
I
feel
don't saying anything about the case. I just trying to figure out why you may want it. I just have to check into that, okay?
Okay.
At this point, the prosecutor just got basically informed that her case is going to fall apart. The complaining witness is going to backtrack on everything and the state is not going to be able to meet their burden.
All right. So you have 2 kids under the age of 2?
Yeah.
All right. Any response from the people regarding this?
Your Honor, just due to the nature of the charges, I would not agree, but I would leave in the court's discretion.
All right. Also, was there a, let's say, provision? I'm presuming there's also the request of the no-go 24627 Norfolk.
I believe that she wants that, yes.
She wants that removed also.
Yes, correct. If the court is inclined to change this, I believe that this situation did include alcohol and intoxication being a factor. If we could have alcohol testing, if he is going to go back, I just have concerns for the victim, given the fact that in this report, she does state he was intoxicated and that he threatened to slit her throat.
I would have no objection to testing that. That is a part of the report. That is correct.
That is part of the order of no alcohol. Is there a level of intoxication?
I don't have a level. I
don't believe it was done at scene. It's my understanding from the report.
Okay.
Whenever I watch these Zoom court hearings, I can't help but feel like I'm watching a bad episode of the Brady Bunch. I know. I'm old.
What I will do in this case, hearing from Ms. Parnell, I will delete the no contact provision. I'll add a provision of no non-consensual contact. Do you understand that, sir?
Yes, sir.
All right. That means that you're only in her presence by her consent. If she doesn't want you there, you need to leave. You understand that?
Understand.
I will also delete the no go-to provision to the Norfolk address.
Thank you, sir.
All right. I am, however, given what has been said at this juncture, I will add a provision. Well, you understand that there should be no consumption of any alcohol by you. Do you understand that, sir?
Yes, sir.
I will also indicate that the defendant, prior to the effect of those orders, must go to community corrections for placement on a silver link tether. So you'll be required to blow into the machine so that we know that you're not drinking. You understand that?
Yes, sir.
So I've ordered that community correction. You must report to them within 24 hours. Did you need a phone number for them?
Yes, please.
Area code 734 973 4520.
This defendant really caught a lucky break. He is allowed to return to the home. The bond conditions of no alcohol was maintained and the judge added testing to the bond conditions.
734-973-4520.
Yes, sir.
Great, thank you.
All right. And I have signed that order. All right. Thank you.
Thank you.
Here. Court calls case people versus Rodney Balhoff.
Caitlin Kirby on behalf of the people.
Teresa Clara on behalf of probation, Your Honor. Mr. Balhoff was scheduled before the court for a review hearing. He has completed all terms of his probation. I did waive his appearance from attending today's hearing. Probation is recommending that the court discharge him from probation with improvement and close his case.
Objection, that's so ordered.
Thank you, Your Honor.
That's something that is always nice to see. The defendant successfully completed all the requirements of probation and they recommended that he be taken off paper. The judge agreed.
Court recalls the case of the people versus Anton Ritter L.
Caitlin Kirby on behalf of the people.
And Assistant Public Defender Melissa Kleeman on behalf of Mr. Antaridorel. I did just text him the Zoom information. I have not heard back yet. It looks like he may have just signed on.
He's on.
Sir, can you unmute and state your name, please?
My name is Shaka Riderell.
Okay, what are we doing on these cases?
And we were just asking for an adjournment. My understanding is he has some more information he'd like me to take a look at before we make any decisions, please.
April 18th, 2022, 9 a.m. or 1 p.m.
Thank you.
I'm sorry, could you repeat that?
Yes, sir.
April 18th.
April 18th, 1 p.m.
Thank you.
Thank you, sir. Court calls the case, People versus Mohammed Shim.
Caitlin Kirby on behalf of the people.
Teresa Player on behalf of probation, Your Honor. Mr. Shim was scheduled before the court today for a review hearing. He is compliant with the terms ordered by the court, and I did waive his appearance from attending today. Probation is recommending that he continue all terms as previously ordered, with the next review hearing July 11th, 2022 at 1 p.m.
I will continue all terms as previously ordered. Set next review hearing July 11th, 2022.
In this instance, the defendant is successfully complying with probation, but they are not prepared to let him off paper. Probation recommended that the terms of probation continue and that another review date be set. Again, the judge agreed with probation.
1 p.m.
I just need to take it down.
All right. We're about to go on our non-public record, so YouTube will come down.
Sadly, I wish this court session was more interesting, but I hope you at least got something out of it. Thank you for watching.